Well, thank you all for joining in on the Skype call last week. We, as I said at the time, find it helpful to walk people through the document and orient you to it before we sit in a meeting like this. And so I hope that was helpful. Hopefully it oriented you to it a little bit. My thoughts for today are, there are, I think, probably three significant changes that we pointed out last week, which I think, at least Laura expressed some issues on one of them, but I want to make sure that there's discussion on all of them. And I'll name what those three are, and I'd suggest we go through those three and then open it up for whatever anybody else wants to raise that came up in the course. I'd advise us not to go page by page because we'll never make it. But the three issues that I think are worth making sure that this committee is clear on are, number one, the fact that we have tried to sort out the zoning administrator from the director position and authorities. That's pretty garbled in the current code. That's one, and I know that there are some concerns about that, the way we sorted it out. Number two is notice, and it's just making sure everybody's clear. The city has been doing mailed and posted and published notice. But under Arizona state law, you only have to do published and you have to do posted if you don't have a newspaper. So the current draft takes out the language at the request of the city attorney, takes out the language about posting and mailing because it's not required by Arizona law. We're told the city has every intention of continuing to post and mail and continue the current things, but the city attorney advised us that she would not like this code to obligate the city to do things that Arizona code does not obligate them to do. I think that stated another way. She doesn't want the city to face a lawsuit over something it did but was not obligated to do, or doing wrong something that it was doing voluntarily. So that's another key issue that we should put in here. It's out, those provisions are out, but it's footnoted that the city intends to continue doing what it's doing. And the third issue is just enforcement, because we know that's been talked about the last several months, and the fact that we have revised and amended and tried to clarify the way the code is enforced and to add what we are calling a ticketing option, a fact that you would be able to cite somebody for a zoning violation and give them the opportunity to pay the fine without going to court. Right now, like many old codes, the only real way to do it is to get the attorney, get the courts involved and convict somebody of a violation of the zoning code. That comes from the era where zoning violations were treated as criminal acts. A lot of what's in a modern zoning code is not a criminal act, nor should it be. If you've got inadequate landscaping, that's not a crime. It shouldn't be treated as a crime. It's just it's like a parking ticket. You ran afoul of the rules of your community, but we're going to treat it like a parking ticket. So we have not changed that. You already have a civil citation process. It's pretty unclear how it works. There are at least 2 or 3 different provisions that we tried to reconcile into one system. And what we did add was a provision saying we can find nothing in Arizona law that prevents you from adding an option in there that says, we've got a fine, you don't have to go to court. If you want to go to court, you can have your day in court, but you can also just pay the fine. And many communities opt for that. So the zoning administrator duties, the posted and mailed notice, and the enforcement changes are the 3 things that I think are significant here. Besides that, most of it is clarification, reordering, and technical changes just to come into compliance with Arizona law. And we footnoted those. I'm happy to talk about any of them, but let's take the hardest one first, if that's okay with the committee. And that is that we have tried to sort out, if you've got your copy of this, it's on pages, the pages that I think are relevant to this are the table on page 5.9 and 5.10. I'm not going to read through that table other than to say, we have tried to say that Lake Havasu City has a zoning ordinance. The job of administering that ordinance on a day-to-day basis is the job of the zoning administrator, capital Z, capital A. That routine decisions, when people come in and say, am I in compliance with the zoning ordinance, are the job of the zoning administrator. And the way they sort it out is if someone doesn't like that decision, they appeal it to the Board of Adjustment. That's the kind of standard practice in zoning ordinances. The job, if things require judgment or the involvement of an approval, a rezoning, a new development, more than just the question, does this comply with the zoning ordinance? Somebody's asking for an approval or a conditional approval or a hearing. That's the job of the director. That goes through the director. The director makes that decision about how to process it. And if that is appealed, that goes to the planning commission rather than to the Board of Adjustment, because the theory is those things involve more than just a yes/no decision as to what's written in the code. And that's what planning commission is for, is things that they involve judgment as to how the town, how city wants to go forward. So that's how we've tried to sort it out, broadly speaking. There's a table here that indicates who would make various decisions. It results in the zoning administrator being responsible for saying, yes, it complies with zoning, here's your zoning clearance, sign permit, airport overlay district permit, does it comply with the airport overlay district, or is there a minor variance here? And there's a list of the things that you can be varied with, which is why it's in this category. If it's on the list, then the zoning administrator can decide. If it's not, then it's not. Then we've got the series of things where the director decides. That includes things where, when we read the text, there is some judgment involved. Temporary use permit, minor conditional use permit, site design review, grading permit, and appeal. Well, that's basically the three. So those are, that's kind of how we've organized it. Actually, I missed it. Site design review is actually a zoning administrator as well. Laura, I think you had some thoughts on this last week about worried about how this works.
Table.
Okay.
I think that's a good way to do it. Mm-hmm. I don't like so many of the duties going to the zoning administrator, and that is because the only appeal is to the Board of Adjustment, which I don't feel is as fair to the public, that it go to the Board of Adjustment, which is a quasi-legal board. And the only people the Board of Adjustment can talk to is currently the zoning administrator. So basically, the zoning administrator decides this is the decision. Well, we don't like your decision, we're going to go to the board.
But they have a hearing.
They do get a hearing, but they're going to a board that is listening to the only person they can talk to is the zoning administrator for interpretation of the code.
But how does that differ from the planning? The planning commission talks to the broader
They talk to
audience.
anybody.
Well, but it's in the context of a hearing.
But prior to the hearing, your planning and
so
zoning.
it's the fact that it's a quasi-judicial that they have to treat it as a. I'm trying to figure out how it is. The goal in most cases is that if you're appealing a decision and the question is, was the zoning administrator right or wrong?
Correct.
No one talks to anybody, but then you have a hearing and anybody can talk and say, I think he's wrong because. Yeah, but what's the difference?
Well, I think if you have the planning commission, they can actually talk to each other, of course. They can call somebody on the Board of Adjustment. Yeah. They can call a city council member.
But they still have to make their decisions.
They can get different interpretations, or, Guy, am I reading this really wrong? The Board of Adjustment, they can only go to staff unless we allow the chairman of the commission to be a member.
Well, and you
which is
that
currently in the code, which will be removed. It's not being done currently, even though it's in our.
Would that be? It would make you happier to have.
I would feel better that they have another person besides just staff that they could go to.
What do you think it would help if the staff that made the presentation to the Board of Adjustment was?
Oh, that definitely would be a different individual.
Someone other than
the person whose decisions is being questioned.
And right now, unfortunately, Stewart's kind of got all the titles.
Well, but I mean,
or unfortunately.
Technically, I think the code says that the director is the one that's responsible to the Board of Adjustment. So I think that in the event,
if your decision was appealed, Greg would have to present that to the Board of Adjustment. That's how you think it reads.
We don't do that.
Well, why don't we put those two things in there? I'm comfortable with those. I understand
that
your
would
concerns
help.
that it is not the person whose decision is being made, being appealed. I understand your concern about that. Nobody wants to look you in the face and say you're wrong. So.
Well, and then you don't want to show up and go, well, wait a minute, you're the guy that told us we couldn't do this, and now you're telling
Well,
us
I mean,
more.
it is the standard practice. The standard practice in appeals is the guy who made the decision goes in front of you and says, this is why I decided it, right? And they have to decide if some of the evidence they get differs from that. So I'm not trying to argue back again.
No, I could see the person being there to explain his case, but not advise the board.
not as the staff person, sure.
Oh, I think that's right. So let's make that change. I also don't object to having the chairman of the planning commission be an ex officio member or a member. I don't object to that. What I don't want to make it, as we said on our phone call, is I don't want the assumption to be that every interpretation of the code is a kind of a
challenge.
judgment matter about the future of Lake Havasu City. Lots of times it is, how many square feet do you have?
Right.
How many parking lots do you have? How many and I don't think the planning commission should be involved in that stuff. That's not their business. They're supposed to be thinking about the future of the city and bigger developments and not whether Stu can read the code. And so that's where I would like to.
I am confused on your table.
Yep.
Under site design
Yeah.
review, we have D, which stands for decision of the zoning administrator, and yet it goes to planning commission, which
Well,
totally goes against.
I think that's my editing problem. Do you remember,
Okay.
Kristen? Well, let's figure out which one's right. Do you remember whether we gave it a decision?
So this was initially, and this is, so initially everything that was zoning administrator was gray.
Yeah, right.
And so in this, when I changed it to the ZA, it didn't become gray. So this was an authority we had originally given to the community service director,
We
thinking there
usually
was some
said
judgment.
D, and then we looked
Yeah.
back at it.
And then talking with staff, we decided that this would be appropriate for the zoning administrator, but then anticipating this conversation that planning commission probably should be involved and not the board of adjustment, and this is an exception to the rule.
Well,
We
or
decide-
we
or
we
it could
change it,
not be.
or we change it back to the director. I mean,
Yeah,
That might be advisable only because there are certain codes or zoning districts that site design is a requirement of the
and that's what we were
planning
trying to
commission,
get away
therefore-
from as
Well,
well. We
we're
were trying to
trying to-
make that uniform.
We're trying to get away from it.
Yeah.
So we either take all of that out.
But
of
here's what
planning-
I don't object to moving. It's going to remind me if there's a reason we did that. Generally, here's the answer.
When
You
do
guys
it
call it
one.
design review.
Right.
Design review usually winds up, no matter who makes a decision, in front of planning commission. Not necessarily for the decision, but at least the appeal would go there, because that's who you appoint to look at planning questions. And so, on the other hand, site plan is really a routine activity that's often done at staff. It either complies or it doesn't. So that's the difference. When you call it design review, but when we read it, we kind of said, this is what they call site plan. They are actually using it as site planning, and that is usually a job for the staff to do. And so that's why, and now, it's coming back to me. That's why we said, let's just call it site/design review. But when I read the content, it looks like site plan review. So how much building design happens in the course of site or your current design review system in most zone districts?
Well, not as much, but what I think a few years ago when we started doing these new districts, there was a shift.
Right, it went up to planning commission
Planning
or
commission.
council.
Right, and I think part of the problem we ran into internally is that typically there's several processes that are running concurrently. Sometimes it has to do with the rezoning, but more so than that, there's other departments involved with regard to building review and whatever else, and by the time you take it through the planning commission and the city council, 60 to 85 days later, the other departments are already long done with their review, and if any changes come out of that, now we gotta go back. If it impacts fire, if it impacts building, whatever, then they've gotta make those changes and go back. So I think it's our desire to go back to that staff review, because that runs concurrently in parallel in most instances with the other staff review of the other departments.
So you want to review the entire thing along with site review?
Well, because on PDs, it gets a little more complicated, but for the most part, on a typical vacant lot, they come in to develop it. All we're really looking for, landscaping, parking spaces, building color palette, landscape palette, there's just not much to it. There's really, in my opinion, no reason to drag that through two public hearings, more or less. Right. And subject a builder or a developer to that. There's just...
Well, in most cases, you don't. It's only with the PDs and the zoning districts that have been created that you drag it through.
You're right.
Hearing. Now, if the director were to make that decision,
Yeah.
then the decision goes through unless there's an issue where the builder or somebody appeals the decision of the director, and at least then he can go to planning commission.
Right. And maybe that's the answer. Have the zoning administrator responsible for the initial review, director, approval.
I'm trying to think which way to go, because I think you're on the right track, and I do think efficiency-wise, most of the routine ones should be at staff.
Yeah.
And not go.
That's right.
Yeah, because that would be.
We're trying, you now have a 2 or 3 track system, we're trying to simplify it. It may be, but we don't know how much we're gonna succeed in simplifying
Okay.
the zone districts. What I would suggest is that for now, we either have to go one way or 2 ways. We either leave it in here, or we create 2 processes. One is site review, which is administrative board, goes to Board of Adjustment, and then design review that goes through the Director and Planning Commission. If we wind up with some districts in which you really are going to have what I would call design review, and maybe that only applies to PDs, maybe that only applies to major developments. Maybe I've created the problem by merging the names here, where in fact there are 2 different things going on. I mean, what do you think we can simplify it to the point where we could just do it through staff, or do you think in the end we may need to have one that goes through planning commission?
I think we can simplify it just going to staff, because that's the way it was before we started creating these
Okay, but then you
form-based.
have to start changing districts if that's the case.
Yeah, we'll have to
But we
look, and I
are,
think that's
because
where
they'll
Don's
split.
going, when we
When
look
you
at those
said earlier
districts.
that McCullough has to go, our evaluation says this is really complicated. It took us a long series of phone calls with Stu and Greg and everybody else to understand the history of how that happened and why it doesn't work. And so,
Oh, there's still problems.
well, we know, but our evaluation was to say we really ought to simplify it significantly and put as much as you can in objective design standards, because then it's not tied up in process. You've kind of set it out in a more. So let's do that. Let's leave it for now that it is going to go to the zoning administrator, and we go that way. But leave the door open if we get to the end and we, as I say, believe it or not, this is not the hard part of this job. The next module is going to be the hard part of the job, where we try to simplify the code and the uses and leave the door open that if we come up with some of them where the appeal really needs to go to the planning commission or it needs to be done by the director, and we're willing to add that in. But let's assume we succeed with simplifying the process.
Okay, and I am a little confused with the review, that the zoning administrator now has this duty of reviewing. Because when you read the statutes, it strictly refers to a decision. So now we're gonna say, well, he's not really making a decision, he's just checking.
We can
that
take those out if you'd like. You'll notice that we put R in everything. The point is that when stuff comes into the office, I am assuming that Greg has Stu look at it before Greg looks
Oh,
at
I
it.
guarantee.
Well, but my point is, that's, we're not in favor of one person or another.
Right.
That's
No,
the
I get
staff's job. Staff's job is to advise their supervisor what they think about this before either they make the decision or before their boss makes a decision. So, is that okay? I mean, there's nothing political going on.
That's a
there.
good
No,
Okay. So you walk into Greg's office and Greg says, "Stu, what's going on here?" Are we okay with this for now? But I want to acknowledge Laura's comment that we should keep the door open, because it may be that we need to come up with a category that goes through planning commission for the. It would, in a city of 50,000, I wouldn't be surprised that we wind up with that. But if so, let's make life a little easier on ourselves and just call them by different things and send them different. The simpler districts go with zoning administrator. I don't want to do it now because I don't know what's going to be in that category yet. But let's wait till we get through the zoning or the zoning simplification, and if that's what we need to do, that's what we'll do.
Cool.
Okay. All right.
And so essentially, for now, the appeal would be with the BOA
That's
under
right.
our
That's right.
conversation.
Under the current conversation, and we'll move it up into the category above. And then, matter of fact, we'll footnote it so that we don't forget that this may be split into 2 categories depending upon whether we need some of these things to go through planning commission. Is that okay? I'm seeing some nodding around here. I like to footnote this stuff just so the public understands the reasoning and where we've left the door open for a change. We remind ourselves when we go back 3 months from now or 4 months from now, we're going back, oh yeah, we said we would think about that and stuff. Okay, great. Second thing I highlighted was the notice, and I saw Laura being concerned about that. I want to be clear that it's just your decision. Do we want notice that is not required by Arizona law to appear in the code, because it is the city's commitment to give that kind of notice, which is what it's been in the past, even though the city attorney has asked us not to do that.
What's her concern now?
She's concerned that if somebody, when a decision gets challenged in court, the very first thing attorneys look for is not whether it was a bad decision. It's whether the city crossed all the T's and dotted all the I's. It's much easier to invalidate a decision for failure to take a right step. And she doesn't want the city's decision to be overturned for failure to do the posted notice right, when Arizona law never required them to do it in the first place. So that's why her judgment was take out the things that we could get sued on, that we'd say, well, we didn't even have to do that. We were doing it out of the goodness of our heart, and the fact that we posted wrong shouldn't mean that we lose the procedural lawsuit. So I'm not making light of her concern.
She'd
That
like to
is
take
her
it out
concern.
completely.
That's what well, her general advice throughout this has been bring this into compliance with Arizona law. And in some cases, it's because some things in Arizona law are missing, and we put them in here. In other cases, there's stuff that is in here that's not in Arizona law, and so she's asked that to be taken out, so. It's your,
List that as minimum requirement?
yes, it does. The law in Arizona is clear. You can always do more. All states allow you to do more, and again, the city has told us, or Stu's told us, that no one's suggested that they do less notice. It's purely a question of whether we put it in the code or not. Laura wants us to put it in the code. I'm gonna short circuit this discussion.
I am for the public, and to me, sure, the city can say, all you need is it in the newspaper then, is what statute states.
Right.
The only notice you have to give is a small little thing in the want ad section.
It's a display ad.
It is.
It's a quarter
but
of a page or
that
whatever,
means
but yeah.
everybody has to have access to the paper, buy it, or go online, or you're not gonna know about notices, and I can tell you, most people don't care if it's happening on the other side of town.
I know.
But if it's happening next to them,
That's right.
down the street from them, the only way they know, and the only reason a lot of them have shown up to planning and zoning meetings when I was
I
on,
know.
is because that block sign was sitting out there saying, and it made them question.
Well, and I
So-
don't want to, it's kind of unfair without Kelly here to defend herself. She is the city attorney, and it's her advice. However, I will say it's normal to put in the code the type of notice your citizens and your elected officials want you to give, regardless of whether that is what is required by state law or whether
Again,
it
if
goes
it's
beyond
just
that.
simply
So-
stated as minimum notice, can't the city then?
Yeah,
allow
it could.
Yeah,
Absolutely,
I guess
absolutely.
Yeah, but we
Not
have
knowing exactly
additional optional notice.
Kelly's reasoning, but what Laura said, that we should at least have site notice.
Okay, you'd like to have at least posted notice
Yeah.
in that for that, okay.
Don't you think so?
Yeah.
She'd like the mailed notice
She
too.
wants us mailed notice to 500 feet or 1,000 feet and stuff.
I would go with that too, but I will say, okay, the mailing.
You'd be satisfied to keep what
At
you had
least
before.
get the Well, because you're saying the state, it's minimum. In a bigger city, I totally understand not having to go through all of this, because you could be talking thousands of people that you're sending notices.
But even in our city, going out to notice 300 or 500 feet can be pretty daunting.
Well,
That part there's
it
condo
can be
associations.
expensive too.
Yeah,
Frankly,
that's right.
so.
I've been there.
But again, remember,
Yeah.
let's not confuse the issue. So far, nobody has suggested that Lake Havasu City give less notice than it does today. Now, that's a different issue.
Well,
The
but
only
it's not a requirement anymore, and
No.
it could be,
Well, no,
you know
but we're
what,
discussing whether it ought to be, I understand that, but I'm saying, let's not get into 300, 500,000 feet, that's not the issue on the table. The
I
issue
would
is,
say my personal feeling is at a minimum, at least you have to do the public notice.
okay,
At least have on-site notice
I would-
at a minimum. And then if someone wants it at the post office, which is something you do normally anyway too, I don't know.
so right now, I will say this also, I think the experience around the country is that, I guess I'll go on record with this, the least effective notice is published notice. Old state laws like Arizona, like Colorado say that's what you gotta do. That's back from the era when that's what legal has. Well, we're writing the codes for Ann Arbor. Ann Arbor, Michigan has no paper. What are you gonna do? But it's the least effective. The most effective notice is posted notice. Because people care about what's near them, they see the sign.
Right.
It's more effective even than mailed notice. So
Yeah.
I guess, I think if you wanted to keep posted in there, right now Arizona law says if no newspaper of general circulation exists, you just take that out and say you're intending to do newspaper notice and posted notice and leave it at that.
And they're back to the mailing.
Is that okay? Well, you would like the mailing in there too. I'm just trying to find where the consensus of the
Well, I'm
group
trying
is
to
here.
find a happy medium. If the mailing, if they're short-staffed, that could be a problem. It is
Yeah.
costly. A lot of your property owners are out of town though, so, but at a minimum, yeah, I would at least like to see it.
Are you okay with that? Let's do that. You know what? We have a new intern, and I've wanted for years to assign. This is an area that's changing significantly because even though it's true that not everybody has a computer, it is also true that many people would rather get an electronic notice when something was happening than a mailed notice. And it's free for the city compared to a mailed notice. And so cities are moving from mailed notice to emailed notice, even though it's harder to manage just because it's free. And once you go to something that's free, you can go as long as you want because it doesn't cost anything to do that. It's the mailed notice and getting it wrong. So let me do this. Let's stick with the published and posted for now, knowing that the city could do mailed notice and intends to for now. But leave that out of code because I think that's going to change in the next few years. And let's have our intern look at whether there's something that somebody is doing that I haven't found it so far. People talk about it, but I have not found in any of the codes I've looked at a really efficient and effective way of using the web. Many cities do it. They just have an open mailing list and say, if you want to be notified, tell us, and we just send you an email notice.
They do that here too.
All right, so we'll look and see whether there's anything more we could do. But
And I will just call attention to H5 for notice for changes in standards governing land uses. There's, and I'm sure many of the processes that Stu's processing fall into one of these categories, and it's still not a requirement, but at least mailed notice is one of the three options. And something that was raised in one of our initial meetings was utility bills, and they had suggested that we send notice of these meetings through utility bills, which we talked about as being expensive, but it sounds like that is one of your processes.
Well, now what about the water bill, since the city has the water, isn't that typing something on there? Wouldn't that
Well,
be-
that's
But that is expensive because
they
they
still
either
charge.
have to do it on a separate sheet of paper, which then requires additional mailing or approval through the management
it's
and
all done
everything.
by outside contract.
Yeah,
from
it gets
one-
pretty
Oh,
expensive in a
yeah,
hurry.
It's not in-house. which-
Yeah, well, not to mention the fact that the way our water billing system works, there's 4 phases. They don't mail them all out in one mass mailing. They mail this sector out, then they mail this sector out a week later, and then they mail this sector out. Well, if the meeting's the second week, only the first group of individuals is
Oh,
gonna get
yeah.
notice of that meeting, unless it's over
unless you
30
give
days
2
out.
months- Unless you give 2 months advance
Yeah.
notice of the meeting. So
Yeah, so that's part of the problem we see with it.
let's leave it at this. I think we have some general satisfaction. This is a compromise that would be acceptable. All right. What about the third issue that I just want to make sure everybody was clear on? I haven't heard any objection to it, is the idea of having a sort of a ticketing enforcement, making it clearer that you could have a ticketing system that allowed people to just pay the fine and not go to court. You got some concerns about that?
That part, I don't really have a problem. It's enforcement beyond that. If they don't comply,
Right. Tell me what
what do?
you do now. in terms-
I can tell you that the mayor is in favor of that concept, starters. But what we do now is we contact the individual, of course, try to get compliance over the phone. If nothing happens, we send out a 30-day violation letter, and of course try to keep that line of communication open. And then ultimately, hopefully, they comply within 30 days, it gets closed and we're done. But if not, then, and you know, we're trying to be kinder, friendlier, everything else, you know, hold hands as opposed to trying to slap people over the head. We have the ability then to turn it over to the prosecutor's office and let them go to court. Now, one of the options obviously would be for them to stand up in court and say, yep, my yard looks like crap, I'm gonna pay the $100 fine or $200 fine and be on my way. Well, we haven't really gained compliance
The
at
yard
that
still
point.
looks like that.
Yeah,
We haven't gained
we
anything.
really haven't gained anything other than $250. Now, if on the other hand, we had something beyond that program, let's say a property maintenance program or something where the city could then go in there, fix it and assess it back, you know, something on that order, then it may make a little more sense, but we don't have any of that.
Oh, okay.
You know, we don't.
Most states allow you to do that. Do we know from our earlier, I mean, this could be something that we missed because we weren't focused on it. Most states allow you to do that.
I think we need to start doing that.
But
No,
with-
not that
I mean,
know.
you have to allow due process. You have to allow them their day in court and
Right.
what all we've said so far is, look, friend, you've had the informal conversation, and you've got a 21-day notice. You've either chosen to ignore us or something. Now you're facing a fine, and if you choose, you can pay the fine, or you can go talk to the judge about it. But when we get to that point, most states allow the city attorney or the prosecutor to choose to go after just saying, look, if we deem it to be a serious enough violation, we'll clean it up and lien your property for it. I don't know if Arizona law allows that. We can check. You would like that. At least
think
two
we
of you would
should,
like
yeah.
that.
Didn't that issue come up with the?
Well, the
village
issue
property?
came up more so with like burnt out structures
Yeah,
and partially burnt out homes where they're obviously an eyesore.
Right.
We've gotten
they're a
after
nuisance,
them
they're a
for
public health
securing,
issue.
yeah, we've gotten them to the point where they'll secure the building, but securing is a 4x8 sheet of plywood over the window and the door and lock on the garage door. Well,
But there's a couple in town.
They still
when
look
that came
bad.
up, there were, basically sticks.
right.
There wasn't even a roof, there wasn't windows, there wasn't a door, I mean, look.
And see, at that
Basically,
point, the
yeah.
council has to tell us to expend money, especially if we're gonna expend money on a private property.
Right.
And especially if we don't lien it, if it's not our, at this point, we don't.
But no one knows
typically lien.
whether Arizona, nobody at this table today knows whether Arizona law permits you to lien the property and for the
Right.
cost of cleanup.
Right.
Many states do. I mean, they do. You have to have criteria in the code. It has to be public health or safety violation or well, but a burnt out house is a public health or safety. So,
Because in those
so is
cases-
rubbish in the yard. I mean, that's a
I
problem.
thought you could, because I thought that came up with,
I think you can.
the attorney before, what was his name?
I know who you're thinking of, the guy from Bullhead.
Well, usually once you can take someone to court, you're really under the rules of that court system. And
Lankowski.
that really turns.
Yeah.
That turns
Oh.
on that, you know, when you go in front of that judge has the power to do what that judge has the power to do. But the idea that you can lien the property at the city's option, clean it up so if you ignore us long enough, we can clean it up and lien your property for it. That's very common in most states.
I think
So-
we need to have
All right,
something,
fair
because
enough.
I can think back on quite a few properties that got to that point, and it just seemed like when you tried to ask questions of, like, the mayor and the council, they're like, well, we're trying, but our hands are tied. So it seemed like there was a lot of red tape
Yeah.
to
Right.
go
Get to
through,
that
maybe
point.
the code wasn't clear enough, I don't know.
And with yard cleanup, what's yard art and what isn't?
What's yard art and what's not.
Right. Because
That's zoning, you're gonna have to change.
That's really.
Well, I mean, let's, I want
Subjective.
to go back, you know, anytime you authorize a city official to make a decision, there needs to be criteria to
That's
judge
right,
that official.
yeah.
What is the difference between garbage and art is a really hard one, but there's no way around it. Somebody, probably the zoning administrator, has got to say, I don't think it's art. I mean, everybody who has a beat up car in their yard thinks it's a collector's car.
Well, it can
It's
be.
not a collector's car, it hasn't run since 1952, you know, so.
No, my neighbor has an airplane insurance. Is that yard art or not?
Well, we would have to put criteria in here, and no one would be satisfied with the criteria, but the only thing you know is that if you don't have criteria, you'll be invalidated, so you have to put criteria in there.
That's right.
My guess is that probably what would make people comfortable is that that we write the code, so the city has that authority, but we probably make it subject to council's approval to do that particular type of enforcement, so that they're all looking at it and saying, yeah, the guy says it's art, and the 7 of us say it's garbage, or
Yeah.
that it's not gonna happen and the city be on the hook for something that's politically unpopular without some amount of political, I'm speculating. Some cities don't require that, but I'm just trying to figure out what Lake Havasu would be comfortable
The
with.
council may not like that, they don't want to be put on the hot seat over what's art and what's.
Well, you tell me, do you think
I
it ought to go
like-
that way or not?
Well,
I'll be clear, most cities don't. I said that because of what I know about this situation. Most cities would say, when the zoning administrator has these powers to enforce the code, they make decisions. If you don't like their decisions, you appeal them. But council does not get involved in enforcement decisions, usually. That's the norm. So,
and that's probably the way it should be. That they're, we definitely need to be able to enforce these beyond a fine.
Okay.
Because, people pay a fine and they don't.
okay.
they
Let's
don't-
check with Kelly. If it is not prohibited in Arizona law, we will add that to the powers that can be done following informal conversations, 21-day notice, imposition of a fine, and non-payment of a fine for some period of time. I think you need to give them several outs along the way, because in the end, what you're looking for is compliance.
Right, exactly.
So,
And I think we ought to do something, as far as giving the zoning, the code administrator
More power.
more power.
to make those decisions? Okay, that's fine. Well, so you want to go the mainstream way, which is that, look, we got a book. We were satisfied with the book. The book was adopted politically after public discussion. The book gives a person the right to administer this code.
I think
in
the
most
only
cases,
danger
everyone-
is coming to a condominium type mentality where you can't park your car in your driveway, you can't, you know.
Too much regulation, too much regulation.
That's the other thing we have to be very careful with, because, you know, people came here because they could park their boat in their yard and their RV, and so yes, we need to address that.
Well, I think the trick will be for Clarion to propose some criteria, that the ability to abate the nuisance and lien the property is subject to some pretty strict criteria, so that, frankly, I mean, I think it has to be pretty strict. You know, when you've got more than, you know, half your yard occupied by various stuff, or
Well, either that or, you know, boat trailers that have flat tires on them for 6 months at a time.
send the Boy Scouts out to fix those things. No.
That's pretty obvious, those boats aren't.
They're not going
aren't
anywhere.
being used, yeah.
Right.
And we have.
Let's leave it at this. I don't think we can solve it at the table. Let's try to, I think the sense is you want those powers if they're illegal in Arizona, and it's our job to come up with criteria and put them in here, and then you'll have to take a look at them at some point. Although the next time we meet will be to talk about another module, we can probably bring that, since this is something you haven't seen, we can bring that to you at that time and say, remember that conversation? This is what we suggest.
I had a few other deals.
Please, now we're through the list of 3.
Okay, and then this one's probably early on,
Yep, please.
but it looks like you're thinking about or presenting getting rid of the PD process completely.
No, there's still a PD process, but we're not gonna have 10 flavors of it, which is what you have in your.
Oh, yeah, no, I.
Well, you are correct, Laura, in understanding. Most cities want to use PDs far less than they do now. You want to try to create zone districts so that more of them can be governed by objective standards and fewer of them have to be negotiated.
Ours turned into using the PD variance.
And many cities do. Many cities do that. And it's no city that I've worked at the last 20 years has asked me to increase their ability to use PDs. All of them have said, this is out of control, we gotta rein it in, it's too expensive. And so, is that do you have concerns
I
about
still
that?
think we need to have them to a degree. I'm not sure I like turning them into overlays.
Okay.
Where that's headed, but we'll see when we get
All right,
there.
so you're willing to give us enough rope to hang ourselves a little bit on that
Well,
until
that
we
is
show
how
you?
they function currently.
Yeah, they're basically
technically-
they become a site specific zoning district in and of themselves, because they're married to a site plan, building elevations.
They have to do
Parking
something.
numbers.
There are restricted developments basically, and they're
Right.
phased in, and if they're not done in 3 years, they're supposed to lose it, however. That never got followed through on the process, therefore some of them are still sitting out there and they haven't
Well,
built.
PDs are hard because, no, what we can do, and I'm jumping ahead because this is really
Okay.
for next month's, or next module's topics. Every city faces this problem because a PD is a zoning action. So you zoned it into a PD. What if the guy doesn't build it? What if he doesn't do it by that time? You can, but there are solutions to it. You know, you can repeal, not the zoning. You can't have zoning in most states evaporate. If council zoned it X, then council has to unzone it from X. And that's what doesn't happen after 3 years.
Right.
You can't have it automatically rezoned without a council action in most states. So what you do is you say, look, this PD is a zone district, but it's subject to a plan. It's subject to an individualized plans that you're gonna build it. After 3 years, that plan evaporates. That plan itself, the zone district is still there, still called PD, but on that 365 times 3, that day, that goes away. And it is replaced by the underlying, what you could have done in that district without the special conditions that you negotiate. It can't be empty, otherwise the guy's got his own district with no rights in it. And so,
Don't we have a similar thing now with approved plans?
Yeah, the
3
way
years?
that it reads right now is that after 3 years, the developer or the owner can come back and ask for an extension.
Right.
And the council has the ability to either
Right.
grant it
That's
or
fine.
disapprove
Leave
it. If they disapprove it at that time, then the next action would be to rezone it back to the original zoning district, which would just be that there would be.
But nobody's followed through.
but you can't force them to do that. So, I mean, presumably the council only decides not to extend it if they're ready to take the vote that says you go back to.
And
Well,
usually
but
the
the problem
developer
is
will
the
come back.
notice doesn't come from the applicant or from the city, therefore it's sitting in limbo. They haven't done anything and nobody's enforcing it. So it may be 5 years and Nelson suddenly says,
Well, I understand the 3-year issue is
Yeah.
an issue, but
so it would be nice to have it automatically revert back to the
Yeah.
underlying zoning district. I think.
Well, I think in the case of the London Bridge, that plan has come back to us
we have a
already.
section.
Yeah, it's good.
I think there's something in state law or
There
something
is.
that requires that it go back before council for another action.
It's something with
Yeah.
protected development after 3
But
years.
we should have a
Yeah, but
process
code
that,
section.
as you say, brings it back automatically at the end of 3 years.
We're looking at your phasing stuff now. But I guess the problem, as Laura says, is that even though it says 3 years, if nobody brings it up, nobody brings it up.
Right, right.
So-
Yeah,
If-
it
if
says
for whatever
council
reason-
shall review, so they must, but
Oh, but
Right.
that-
But then
Like,
again,
how
if
do you-
staff doesn't notify the developer or the owner, or, let's say the owner changed, the ownership changed.
Possible, yeah.
And if we don't have the staff to keep up on those, or we don't have a tickler file coming through telling us, oh, wait, this zoning is coming due in
So,
a
yeah,
Well,
month.
but you could have the opposite problem too. You could have, I mean, I think you ought to have a system where there are lapsing, there's automatic stuff, but you still have to notify the guy. I mean, it could
Oh,
occur,
sure.
he doesn't know, his subsequent buyer doesn't know, it's an honest mistake, you're busy. So somebody has to, you can't just wake up and learn that your zoning evaporated,
Right.
because you got a notice, you decided not to
Entitlement.
respond, and
Yeah.
went forward. But I do think the better practice is, instead of saying city council may zone it, city council can zone it back anytime they wake up and feel like it. Is to say, the contents of your plan, if you ignored this, you got notice that your plan was gonna expire, you're out of money, you don't care anymore, you're a new buyer, you got different plans, and you let it expire, then it's not an automatic rezoning. It is simply that the plan's contents are whatever are in the underlying zone district. If you went back to what you had in that part of town originally,
Yeah.
because that way, even if council's busy, everybody else is busy, you've given them notice, people ignored it, now the guy, you can't force council to rezone, they may not be in a mood to rezone, but in the meantime, we know what his rights are. His rights are what they were before, and if he wants to come forward with a new plan, he can do that. He can say, I got a substitute, do I have a plan now? Yeah, it just doesn't, it says underlying zoning, but I want to come in and try to amend that
I
plan.
like that.
But we need a system that will automatically make that notice.
Well, the development plan goes away, they have their underlining.
But he's saying he wants a plan that somehow automatically gives him notice when you
Well,
are
that's-
35 months into a 6-month plan.
Yeah, right. Mhm.
That's just a trigger date.
That's
on
just a
somebody's
staffing,
computer.
That's
yeah,
okay.
that's
That's
just a
okay with
staffing
you?
issue.
You could do.
Is that okay with you?
Well, not if I'm the only one that's gonna be doing this, but yeah, it is.
The bottom line is you
have a
can't
new
trigger anything
system, Stu,
automatic.
don't
until
you?
you
Maybe
notice.
there's some
Yeah,
setting
that's
on
right.
there.
Okay.
The problem we've seen, and the reason I'm kind of being a hard nose on this, PDs were intended that they had this awesome plan,
Yeah,
they
yeah,
needed
yeah. We
exceptions,
know,
they're
right.
ready to go.
It's not a package of
But it
variances,
really
it's real
wasn't,
benefits
right.
to the
Most
city.
of them were doing it to increase the value of their property and resell it. So then they sit on it in the city here, we've done all this and expect these nice
Waited,
buildings and there's nothing.
So let's do that.
Lot
We will
more
come up
pressure.
with a provision clarifying what happens after the notice is given, and then
But we need a notice. We need to
Absolutely.
notify the owner.
we'll modify the PD stuff in here to clarify notice, and then the fact that zoning doesn't go away, and it's not just an option for council to rezone. It is the plan's contents become the underlying zone district, or those are the underlying zone district.
Right. And the only other thing we gotta be careful of is Prop 207, because you could consider that if you've received all these exceptions or height exceptions, whatever they are, and then all of a sudden those go away, you could make an argument that diminishes your value.
That's right.
Well,
Therefore,
it isn't, state statutes has that provision of, I don't know if they call it a protected development or a something development that allows it to expire within 3 years. So as long as we call it that, we're protected.
Let's talk to Kelly about that. Let's
Yeah,
talk to
yeah.
Kelly, because you may need to say, it may need to be drafted in such a way that
you have to
your
call it something
PD
different.
is not an entitlement until you
Right.
build in accordance, until
Right.
you begin
Yeah.
building in accordance. You,
Yeah.
corporate,
Yeah.
you never,
That was coming
you
up.
never had those rights. Those rights were contingent on you moving ahead in compliance with the
right.
pretty pictures you showed council.
Right.
When you failed to do that for 3 years, you failed to finalize the rights that you had. under
I mean,
this
I
zone.
guess
But let me
that,
talk to Kelly as to whether that.
that kind of notice can go along with the original PD
That's right,
and
exactly.
make it their responsibility.
That's right.
And
Because
maybe
if
you
they
need a
let it
development
expire-
agreement.
Or you could just do it as a vested right. Your rights vest when you invest based on
That
that.
would be
But let's
for
talk to Kelly. This is a
development
tricky, I
agreement.
guarantee you that every state's vested right stuff, and nobody wants to be unfair. We all want to be
Right.
unfair. It's just, it's not supposed to be a game that you
Right.
play
That's
for
right. speculative
development that takes staff time, public time, and then nothing happens, and your hands are tied in order to go back to where you were
Right.
before. So,
And then you had a notation about the reasonable accommodations,
Yeah.
where that should go, so we don't need to go over that.
Well, is that okay with you? Didn't we say I thought that ought to go to the board. Where did we say?
You had
You pointed
them,
on what
it's
page on?
5-6,
5-6, yeah.
revised to clarify, VOA may also consider.
Is that what it is?
To avoid liability and administrative.
Yeah, this is the one I couldn't find the other day.
I know on real limited stuff,
Yeah.
like the example you gave at the meeting, a ramp or
Handicap
something,
ramp and a setback.
not a big deal, but if you have one of the bigger issues that we had with the sober home
Yeah.
and reasonable accommodations, then, and the city ended up drafting a new ordinance, so are we 86ing that? Are we gonna use that? I thought that was
No,
something
if
we
there's
were
a,
looking
you
at.
have a new ordinance dealing with sober homes?
Well, reasonable accommodations.
Dealing with reasonable accommodation?
For
We need a new ordinance.
disabled, it was, yeah.
Well, wait, we should have picked that up. Do you have an ordinance
Yes, it
on
was, you guys
reasonable
approved, the
accommodation?
council approved that, and it was to appoint a hearing officer that was hired outside of the city.
No, I think what happened was we as staff got direction to rewrite the code because of that particular instance. We drafted some language, we took it to the planning commission, the planning commission approved it, but at that point, we were in the process of hiring you, and so the direction was, don't go making amendments to the code now when they're gonna look at the code as the whole.
I would double check that, because I thought it went to I remember talking to council.
No, I'm sure Laura didn't.
So
I was
somebody
at the
needs to
meeting
give it,
where I
well,
talked
let's
about
do
it.
this. Somebody, why don't you give us that language?
I
And
will
since
look-
we
yeah.
weren't aware of that,
Yeah.
I think if it had been adopted, we would have been aware of it. So somebody give it to us and we'll take a look. Do you know what you said, hearing officer outside the city? That's fine with
That
me
was
too.
their solution. I don't know if that's the answer on some of these, but if it's to
I
the
understand,
point where
yeah.
they already have legal counsel, do you really want it at the Board of Adjustment level? Because in one case that I can recall where there were attorneys, it ended up being the attorneys became the ones presenting the information to the Board of Adjustment. Staff was kind of
Yeah.
really changed.
Well,
around.
we,
So-
as you recall, Kelly's conversation the other day, in the other case, appeals of conditions and exactions, she wants it done so that there's an outside hearing officer will be
It was
hired,
just
rather
a-
than having, no, but my point is, when we first drafted this, that really wasn't on the table. Kelly
You
would
have
like
one
that to
anyway.
say, get rid of this language about the P and Z Planning Commission acting in that. We'll just hire an outside person. If there's gonna be one case where you're gonna do that, I don't mind creating a second case where you're gonna do that. Where
Yeah.
this is another situation where we'll go and hire one.
Yeah,
Okay.
that would be good, because we definitely need some direction.
And that would be consistent with
Yeah.
the emerging direction that staff came as to how you're gonna handle this, which
I just
we weren't
wanted it-
aware of.
Yeah, I just wanted it consistent.
Oh, I'm fine with that. I'm fine with that. Okay. right.
Um,
And let's send it one way, they're not two. You're not gonna get these very often, guys. You get one every few years. You can have something.
I know. But we don't have anything right now that pretty addresses
I
that.
know.
Okay, well, time limits and extensions,
What page are you on?
5-19.
Okay.
19.
Okay.
Numbers B and C, I'm not really sure.
D.
I have never liked these. I think-
B and C? Okay.
Yeah, I think this is in our code now. The first one under section B, the second one where they need to at least have a building permit and substantial construction. Substantial construction, this came up on several issues of what constitutes substantial. If they come in and grade, is that substantial? Do they have to build the outside frame? So I don't know if there's a better word to use
Okay,
other than substantial to clarify that better.
we can.
Unless it's all as determined by the director, but then you run into inconsistencies where it turns zoning into,
It's not hard to fix as long as this group has some consensus on it. Grading is not substantial construction.
I would not.
Usually,
consider
it is at least construction of the foundation. Nobody hires a contractor to pour a foundation for a building that meets building code, meaning that it's not just concrete in the ground. It's gotta be something that is consistent with their approval and it meets building code. I don't know anybody who pays for that unless they intend to exercise their rights. So I would say, if you want us to be more clear, we say proceeded at least to the point of completing foundation, something like that. Is that okay with you?
I think we need something a little bit
Yeah.
more.
What's the
Just
first
because-
stage of building inspection? What's the first thing?
It is that foundation
Yeah.
inspection.
Yeah.
Right.
But you guys, there's several people who would like to see it go beyond that. Say it's extended beyond building foundation. to
Well, when you
construction
get
of
to
walls.
C,
Yeah,
they can,
Well,
you can take that building permit and extend it out. I mean, I called and that's why I don't like the building permit.
yeah, no, but that's kind of the standard thing is, look, there's kind of an on-off switch. Once you've started building, there are lots of things that can slow you down. But we're considering you a serious builder because no one throws their money out. So you got a permit, you're building, you're not throwing your money away.
Permit and start at the foundation,
Well, I can think of several buildings that have been getting built.
But what are you gonna do about it?
5 years
But
now, and they're just,
But
they're
what are you
still
gonna
up
what are you
down.
gonna do? You can't force the guy to get a loan out of the bank, and if you repeal his building committee, you're left with a half-built building.
We have it anyway.
I know,
guess,
but
so
they're
I
not.
don't know.
Usually you would assume that if someone's gonna spend 50 grand on a building permit, that their intent is to build it. And,
Right.
Okay, and
I
maybe
mean, that's
some
a drop in the
exceptions.
bucket for some people, but
maybe for
There are some
most-
exceptions.
Well, I know there are half-built buildings out there, but it's usually because the guy's running into financial trouble, and you
Right.
can't. If the guy's bankrupt, you can fine him all you want, but he didn't have any money. If he had money, he'd
Okay.
finish the building.
Then I guess if we keep the PD process, then maybe I would like it worded different in the PDs.
Okay.
Because otherwise they could take your 3-year time limit and extend it on forever.
but that's at the request of the council. I mean, the council still has authority to say, no, we already gave you an extension, we don't need to give you another.
Not if they have substantial completion, or
Oh,
they
if-
have a building permit and they're doing phase 1,
Oh,
they
sure,
can say,
sure.
oh, no, I'm within my rights to continue this, even though I haven't really done anything.
Well, phase development is different than, I mean, phase development, you can repeal in the later phases, or you can refuse to honor the later phases.
As long as that's clear.
Okay, all right, so I just wanna make sure I'm hearing this correctly. We're okay, even though it's just one of the weirdnesses of how development happens. If you build a building permit and then you run out of money, we poured the foundation, we've said, look, you spent money on a building permit, you spent money on a foundation, we inspected the foundation, we're saying, you've exercised your rights on that. But that's different than a phased development.
Okay, then
That's
go
what
to
I'm,
your-
that's what I'm
Yeah.
hearing, is that if you've got a 3-phase development and you've tripped on phase 1, we may just very well say, look, we're not extending phase 2 and phase 3. You obviously don't have the money to do
And
what you
you
said.
have
you're
a
gonna do, so.
78, number 78, that addresses phase development, that you removed it, so I don't know. if
Okay,
you removed
let's
it
take a
'cause
look
you're
at, we'll look,
replacing it or what.
we'll
So
look at
that was more clear.
number 78 in the current code.
Well, on your notes on 519.
Oh, I'm sorry, the footnote
Yeah, so
seventy-eight.
that's-
78.
Regarding child loss.
So I don't know if that meant you were gonna replace it with something different.
saying
if
it's been
it was
removed.
gone.
We took it off because there were references in here to a planned development permit, capital PDP. And it really doesn't exist. What you're talking about is an approval under a planned development somehow. So that's why we took it out. But I guess you're saying you still like it addressed
Some,
generically, not tied to development
If we
PDP, but
if we keep planned developments.
I understand.
So, yeah.
Well, I'm not, we're not proposing to get rid of planned developments. I think every city of 50,000 is gonna find it, you just need to tighten up. I haven't found a city of this size that can live with never having a planned development. It doesn't happen, so, okay, yeah, just so. Just so. Okay, what's next, Laura? Or anybody else, anybody who else, I saw, so you're making notes before the meeting started?
I just have a comment under 5-36 on temporary use permits.
Okay.
Limited to 3 consecutive days for allowed temporary uses identified in a permitted use table. 3 consecutive days, I think that we've got a lot of temporary use permits that come that occupy premises for more than 3 consecutive days. What are we doing with them? Fireworks booths, car dealer sales?
The way that the code reads right now, there's 3 types of temporary uses. The ones that are really don't require a permit or that are mostly insignificant, car washes, the one-day
That's under
events.
F2, that's your
the one-day
category
events.
one.
And then at one point in time, several years ago, the only other option was an up to a 30-day temporary use permit. And what we found is that the guys that were just doing the long weekend things or less than a week didn't want to pay the $485 or whatever it was. So we said, okay, well, in order to serve you better, we'll come up with this intermediary, which was the 3-day event thing, where certain things qualify for that 3-day. They get the fee. It's like $75, something like that, and they get to do what they want to do for 3 days. But you still have the ability to get a temporary use permit for up to 30 days, and those are the ones you're talking, like Christmas tree sales,
Car dealerships.
Well, car dealerships usually do the 3-day one, traditionally.
I've got one now I'm working on that's a week and a half.
But yeah,
It's
and
a
in that
special,
case,
a special sale,
they-
a special, is that,
they
that's
spend
what it is?
$400.
Yeah, as long as they get that longer permit.
Yeah,
As long as they get that longer permit, they're fine, and that's up to 30 days, so they don't, I mean, they don't have to be 30 days, it can be 12 days, 15 days, whatever.
Do we want to put under F1B, should that, I mean, we've said these longer ones are being identified in the use table. We do think this is the right thing. When we bring forward, instead of having a separate list somewhere else on the table, the use table tells you which ones are short and long. But do we need to say 30 days here, up to 30 days, to be consistent with what you're doing now? Under
Yeah, we
1B.
probably should.
Yeah, probably.
So the first one says up to 3 days, can't exceed 3 days, and your bottom line, your B is up to 30 days.
Yeah, and then to just take that one step further, the up to 30-day one can only be for that location per calendar quarter. And the reason we get away from, that we have that restriction is so that people can't pile them up for spring break and run through 30 days
Right.
and then turn around and apply for another 30 days and then another 30 days. They can move to a different site and go for 30 days and
Okay.
then
No, I
come back
understand.
60 days later and hit that same site.
Well, no one has suggested to us before this meeting that the system wasn't working, so I think we need to clarify it so that it matches what you're doing now.
Mostly what I'm concerned about is these, all these that are addressed in here are like nonprofits and things
Yeah,
like that.
yeah.
But what I'm talking about is strictly a
Right,
commercial
right,
use.
right. And there will be that F1, A and B, which is in each category will be in the use table that we present next time. But yeah, our intention is to carry forward this system of short and long and exempt ones. So,
Are we doing anything, Stuart, relative to what's going on with Parks and Rec right now in the parks?
No, we're not addressing
You're not
that
addressing
commercial activity in this at all.
That's just a permitting, the
That-
Parks Department can allow things to happen. Is that right?
Yes, that's what they're struggling with right now, as to how to deal with that. If there's gonna be a permit, and if so, for what type?
Right.
Are those uses, do they need to be specified?
Denver's struggling with that too. And can it be a
Commercial
money-making
use of the park.
operation?
Right.
How
Commercial use of the park
how many days of the park can you occupy?
Versus passive public use of the
Mostly, here's how it usually happens. Most city administrations really prefer to have that be a part of park administration and sort it out on the basis that it's publicly owned land. We have a department that manages that land. They're accountable to the elected officials, and if we get it wrong, they'll have to change their tune. Somebody will get elected, tell them to do it differently. But I'm serious, but if you
No,
put it
I'm
in
not.
zoning, it really gets awkward. When those things wind up in zoning, it's because the citizens demand that they put in zoning because they don't trust their parks department to manage it properly. And I'm not saying, that could happen, but I don't think there's a need to go there unless you're getting that pressure. I think you try to allow your parks department to manage them as much as
Yeah,
possible.
that may work, I guess at this point, we don't know.
And that's what they're struggling with at the Parks Board. They're trying to
But I'm
feel
just
their way through.
trying to help you with the thought process, which is, if somebody asked me, Don, is it normal to get out of this problem by specifying in the code? No, it's not normal. Most cities try to avoid that because it's hard enough running a city without having the city run into its own zoning code when it does what it thinks is the right thing to do for the people. So,
And I am confused with this section L,
okay, which is F
5-51,
51.
where we're rezoning to plan
Okay.
development overlays. And I know it's because of these sub-districts and what they call them and how they're functioning, which I don't like them anyway. I always looked at an overlay based on the definition in statutes as something that, due to the significance of the geographical area, you either needed special restrictions most of the time from an overlay. It was more restrictive development because of the area. Whereas the new way would take PD1, sub-district 1 through 10, whatever we have, and allow more uses
Yeah.
in now this geographical area. And I know this might be because of the rezoning of properties that gets you away from the legalities, I would think,
Well,
because you're not really rezoning it, it's an overlay.
I-
So you could change that in the future.
No, I don't think that's what's going on, and I understand your comment. Most cities, and I think most courts, treat rezoning to an overlay as just a rezoning. It is the same as a rezoning. You're not going to get out of any of the Prop 207 or the due process issues related to zoning when you put it in an overlay zone. It's another layer, but it is still a legislative act of the council to subject you to different rules.
But if we do our sub-districts as overlays, then if you have the correct land use, you couldn't go outside of that geographical area and request it. because
That's right,
now it's an
that's right.
overlay.
That's right.
So I think it solves that problem. But once we make them all overlays, does it now give all those rights of what that PD district to everyone that's in that boundary?
I think there are two issues. One is, we do need, once we sort out, try to simplify the basic zone districts, which we'll be talking about next time. It's unfair to go back in time. If people who have PDs, if we find that the way we've defined or tried to simplify the code allows them the same or more stuff than they have now, then they probably need to keep that. I mean, we're not trying to, no one's told me to try to wipe out the existing PDs.
Okay, well, no, but what you don't have is all of these sub-districts, they have not had mass rezoning. So no one currently within these areas have that
I understand.
zoning.
I
But
understand.
once they are turned into overlays and they're approved, now they've all got them all. And if we find we don't like it in the future, we can't take it back, because then they are to us.
Aren't overlays usually more restrictive than the
Well,
district?
yeah, they are. This is-
But sometimes they're less restrictive, sometimes they're less
They
restrictive.
are,
and
they
you need
allow
to be-
different uses.
The classic example is a downtown where you have strict sign limits all through town, but downtown we want it exciting. So downtown you can do additional types of signs because it's downtown. And so my point is, I think you want a PD tool that has criteria in it so that council approves them when there is a benefit to the city. That's one issue, but bear with me.
That
But
one
it's-
I'll go with.
Well,
I
we
can
need to
see
do,
it.
every city should be doing it. You should only going through this brain damage if you're gonna get something out of it, and not just a package of variances. But I don't think it should say that it's only restrictive, because I can think of several instances where you may wanna make it less restrictive. 20 years ago, they were all more restrictive. Now, usually they're drafted to say, the overlay trumps what's underneath, whether it's more or less restrictive. You can ratchet it down or ratchet it up, doesn't matter. Either way, it's council's judgment that this is what happens. But I want to be clear, this is the process for approving overlays in the future. This is what we're
That part I don't have an issue with.
Okay.
What
You
I'm
want to
having
know
a
how they're
problem-
going to be treated, the ones today.
With
You
the
don't,
10
you don't
districts.
want to take the 10 sub areas and say, poof, you're approved PDs because you have not actually approved PDs in those. We're not going to do that. That's not fun. We're not trying to, this is the process that's trying to straighten out how you get PDs in the future. Next time we meet, we'll have to figure out what we do, how many, if any, of those PDs that have been approved need to stay on in some form. But I don't know the answer to that question. I haven't wrapped my head around it so far. So,
That makes more.
I know, we're not trying to grandfather stuff that
Oh,
hasn't been
thank
done.
God.
So,
Yeah,
no,
I've got it.
okay, great.
Okay, I will read all of that.
Well, no, it's
That
not,
in mind.
okay, yeah, please do. We're trying to straighten out the procedures moving forward and then figure out how to be fair to people who already got stuff approved, so.
Okay, now I'm assuming I didn't go through all your definitions because we talked.
Don't, please don't. I'm serious. If you want to do it, we're happy to get your comments, but you'll wish you hadn't, because you'll be reading
You're
it in 6
gonna
months.
fix those up, man.
They're gonna change. They're
Yeah,
gonna
the
change.
footnotes will alert you to the ones that have changed.
But I
and
would
they're
read
very
them,
few.
I would read them once when we get through all 3 modules, and then you can see, because
Well, because there were issues I found back.
with the
when I was-
existing ones?
Oh, yeah.
If you send
Where
them,
there's
if
conflicts.
you've got spare time and insomnia, send them to us, and we'll note them anytime we get them. It's just that I don't think it's a good use of time to.
Well, that's in the current code. We were already starting to mess with them, so we're gonna wait till the end.
You sounded like you had another concern or comment.
No, I'm
Just scrolling through the document.
just kind of scrolling through.
All right, okay. Did you have other comments about?
No, I think you touched on all the ones that I have.
Okay.
I'll throw in one more quick.
Please do. That's why we're here.
In the table of contents,
Uh-huh.
I'm sure you're gonna get into this, you've got for section 14.2.03, mixed use zoning districts, you've separated them between neighborhood and general.
Mhm.
And I have an understanding why you're trying to do that.
I'm afraid my head is not, my head was in it when we sorted those out. If you're asking me why we did it, I don't remember. Let's talk about it next time when I do remember.
I could see it applying or being necessary.
Do you remember generally? I think it was
It's
trying to make
probably
sense.
because of the McCulloch downtown.
I'm sure it
had
had
those
something to do with
splits.
that stuff. I'm sure it had
But I
something.
just want to make sure it's not opening the door to
Oh.
get mixed use in our residential areas, because nobody wants
That,
that.
no one has instructed us to do that. That's not the,
But down, McCulloch downtown,
It already has.
that's
that was-
all he
yeah.
has.
No, we're trying to
Well-
reconcile and call them by the right names. Some of the things you won't
Yeah.
call them mixed use, I'm not sure I call them mixed use and vice versa, so. But no, we got enough trouble trying to straighten out what you got now. No one has asked us to try to leaven. Now, but let's say this, when we come, right now, no one's asked us to try to get any commercial or non-residential uses in the residential neighborhoods. When we come back next week, or next quarter, and we lay out how we think the zone district melange can be sorted out a little bit with the overlay districts, and we put out a table of what uses are allowed in which districts. If we think there are places where some higher density residential districts nowadays do include small convenience stuff, we'll tell you that, we'll advise you, but we'll flag it.
Yeah.
It won't be on single family type stuff, but when you get into the upper multifamily stuff, increasingly, people say, well, it's the people living in apartments.
Should have a
Right.
corner store.
Yeah, I'm not sure we have to zone every
This
corner
was
for
a
that, the
neighborhood
developer can
commercial
put it in there
area.
and let the
It
market.
is, yeah,
So-
that's exactly.
But we'll
Yeah.
flag it for you, there's
Well,
no
we have
grand
that-
strategy to do it, it's just,
Okay.
we'll bring you the best practices that we see in those
Well, and they
areas.
use that commercial nodal, which isn't clear.
She's
Either.
talking about in the general plan.
Oh, that's general plan, sorry.
Yeah.
So, we took a long time to sort this out, and I'm gonna have to get my head back into it. a little
Okay.
bit, so,
Oh, because
ta-
you already got that.
We're
part started.
still in procedures right now.
Yeah, this
so.
is up next.
That'll be,
Kristen and I have our work cut out for us.
We're gonna have a lot longer to review that.
Well, why don't I say this?
Yeah, you're right.
This has been helpful to us. Thank you for making the time to work with us. It really, it's going to, and if you can just keep council apprised of how we're doing, I think we got good compromise. If you read it again, and I mean, if you got nothing but spare time and you want to read it again, we're always open for comments. I think what it would be helpful to us to do is if you've got additional comments, send them to Stu, so Stu's aware of them, and he'll send them to us and probably copy people on it, and then we're never closed for business. So you can collect them, you can send them on anytime you want, and if it's something that we need to discuss, well, next time we meet with you, we'll say, well, we got this suggestion, what do you guys, Laura suggested X, what do you guys think about it? I suggested Y. So we're not closing the door today, and we'll take, and if the public gives comments to Stu, he'll pass them on and copy you guys, so.
No, because you're doing that tonight now.
Well, and
Well,
at
we'll do it
first
tonight, too.
I was.
But I guess my
curious-
point is, mostly we're going to, in general, we're not gonna issue a revised version of this. We're gonna collect these changes, make
Right.
notes of them. We do module 2, you do module 3, then we put them all together here. So, but if it's something that, if somebody catches a typo or something, we're not gonna bring it to your attention. But if it's something that this group ought to deal with, then we'll bring it back to you again. Next time, we're not gonna email you all the time, just bring it back next time we're down here. So,
And just so that you know, I was trying to figure out what direction you were getting. And I was worried, Guy, are you getting too much input, this, that, and the other? Well, now I think after talking to various people in the city,
Yeah.
it seems like you've basically been told, here's our code, here's the
Fix it.
history, fix it for us.
Well, that's right,
And I
and
guess-
make sure it aligns with the general plan update when we get there.
And with the state statute.
And the state statute.
And I just want to make sure that the one piece that, you don't want too much direction where staff is rewriting the code to fit what they see. But you also don't want it just so it's illegal,
Yeah.
which I see starting to happen to a degree with the city attorney saying,
Mhm.
oh, well, minimum state statute, so if we have a court case, it makes your job easier, which I totally get.
Yeah.
But we are different and unique as a city, so
Sure.
we do want other things in there that aren't just minimum statutes.
Well, and
or-
that was Kelly's contribution, and it's her job to
Right,
do that.
sure.
Our job,
Yeah.
our view is to say, how understandable can we make it, how internally consistent, where we've had our attention drawn to things that are tripping all over each other, or that are tangled up people, to sort that out. And frankly, our job is to say, when we look at something, even if nobody's mentioned it, we look at it and say, there's a better way to do that, or most cities your size would do this a different way, to volunteer that and give it to you in footnotes, or even draft it and say, we know this is new, but a lot of people are doing it and they like it. It's a better way to do it. So I don't want to get the impression it's a dumbing down to just Arizona statutes. Our view is we're supposed to bring you best practices, and it's up to you to say, look, that doesn't fit like Havasu said, we don't want it, or gee, that sounds wonderful.
Yeah, that's right.
Okay, it was just nice to finally figure out how you were being directed, I guess.
Your first comment was 2/3 right, fix it, and the other
Well,
third
there's
is,
a lot of
and if you see stuff that we haven't brought to your attention that are good ideas, then tell us. I think
right.
that's a fair. Well, is that fair, Stu? Or not?
Sure.
Okay.
When can we expect the next one? Approximately.
No,
Yeah.
I think technically the public meeting is supposed to happen in January, right?
Yeah,
But
January is the next.
we need to get a staff draft to you guys so you can process it before we do that. So, I mean, November, December, I don't want to, it will not be October. it'll be November or this. I'm just telling you the truth, guys.
No, well, that's gonna be.
And we will ask you to participate in another Skype call to walk you through it, because this was, I don't want to say the easiest, but this is, yeah, it probably is the easiest module. So if, even though that last call was kind of short and sweet, the next one will be longer. We'll really need to have processed it with you before we sit down with you. So, thank you.
Thank you.
Thank you for caring to listen in. Thank you.
Okay, now tonight you guys present all this to council?
We are going to do a short presentation, no, not to council, to the, it's a public meeting.
Oh, just a public
It's, but we're going to go through outline of what the process involves, what our goals are, the direction we've been given, and then the highlights of this stuff. We'll show them the table, we'll show them other things. We will update them on what you told us this afternoon, so that in case they have reactions to that. I think that's usually an efficient way to do it. They're
You
here
guys have many
listening.
people showing up?
No, there won't be very many people. This is the least,
Especially this section.
this is the least sexy of all the sections, you know. But for example, we'll call their attention to the very same notice issue that we did, and the enforcement issue, the things that I think, if I bothered to show up for a meeting like this, I would want someone to have highlighted for me. And then I could pick up the phone and call my councilman.
I think when we get into the next section, the land
Right.
uses and stuff, is when you'll have people
Oh, yeah.
asking questions, real estate agents,
Developers and.
well, yeah, builders.
Zoning thing is, front yards and that type of thing may be of interest to some tonight.
Yeah, that got real hot with code enforcement.
Well, I think this is clearer, but I also think with the changes that we've discussed today, it'll probably work smoother. So at least it has more options. So that's good. So thank you all. Thanks for being here.
Thank you.